5 seconds to go. Start. The provision in the form of Section 45 of the 2002 Act as applicable post amendment of 2018 is reasonable and has direct nexus with the purposes and objects sought to be achieved by the 2002 Act and does not suffer from the vice of arbitrariness or unreasonableness. As regards the prayer for grant of bail, irrespective of the nature of proceedings, including those under Section 438 of the 1973 Code, or even upon invoking the jurisdiction of constitutional courts, the underlying principles and rigors of Section 45 may apply. The beneficial provision of Section 436A of the 1973 Code could be invoked by the accused arrested for offence punishable under the 2002 Act. The process envisaged by Section 50 of the 2002 Act is in the nature of an inquiry against the proceeds of crime and is not investigation in strict sense of the term for initiating prosecution, and the authorities under the 2002 Act referred to in Section 48 are not police officers as such. The statements recorded by the authorities under the 2002 Act are not hit by Article 23 or Article 21 of the Constitution of India. Section 63 of the 2002 Act, providing for punishment regarding false information or failure to give information, does not suffer from any vice of arbitrariness. The inclusion or exclusion of any particular offence in the schedule to the 2002 Act is a matter of legislative policy, and the nature or class of any predicate offence has no bearing on the validity of the schedule or any prescription thereunder. In view of special mechanism envisaged by the 2002 Act, ECIR cannot be equated with an FIR under the 1973 Code. ECIR is an internal document of the ED, and the fact that FIR in respect of scheduled offence has not been recorded does not come in the way of the authorities referred to in Section 48 to commence inquiry, investigation for initiating civil action of provisional attachment of property being proceeds of crime. Supply of a copy of ECIR in every case to the person concerned is not mandatory. It is enough if ED at the time of arrest discloses the grounds of such arrest. However, when the arrested person is introduced before the special court, it is open to the special court to look into the relevant records presented by the authorized representative of ED for answering the issue of need for his/her continued detention in connection with the offence of money laundering. Even when ED manual is not to be published, being an internal departmental document issued for the guidance of the authorities, ED officials, the department ought to explore the desirability of placing information on its website which may broadly outline the scope of the authority of the functionaries under the Act and measures to be adopted by them, as also the options, remedies available to the person concerned before the authority and before the special court. Stop.